Hi, welcome to BL Business Branding. I'm your host, Nick Martinez, and here with my co-host, Isabel Wadsworth. Today we're going to talk about a trademark dispute between Steve Madden Footwear and Adidas over the three-stripe trademark they have for their shoes. So here we're going to kind of dive into the history of Adidas's marks and then what Steve Madden is trying to do. And then Steve Madden's kind of allegations of unsavory or anti-competitive business practices, and then kind of try to find the line between when something is taking inspiration from a design versus when you're infringing on their protected mark.
Right.
And so why don't we just jump right into Adidas's well-known, pretty famous
Absolutely.
Three-stripe mark.
Yes. Everyone, I would say, knows what an Adidas shoe looks like. I don't think, that's a little bit of a generalization, but I think that's fair to say that, pretty much everyone is familiar with this brand and has been for several years. It's a brand with a lot of history. It has established itself as a truly strong brand, not just with shoes, but with clothing, and especially with sportswear. And so, it's definitely a well-recognized brand. There's no denying that. And the history is robust in terms of the development of each product, the story behind each product, and people have a real attachment to Adidas shoes, Adidas clothes, especially, in sports, especially in this country. So, and as you see on the screen here, this is the fairly recognizable design that you see on a lot of Adidas products, the three stripes. It's a legendary brand, and you see this type of design over and over again on the Adidas product. So it's very well established.
Certainly, and whether it's the footwear, the jackets, tracksuits even, the three stripes is throughout all of their products.
Yes.
It's very well recognized. I think the company is some 100 years old out of Germany, and it has worldwide recognition.
Right. And so diving into the dispute here and getting more into the, kind of what's happening with Steve Madden and Adidas, in May of 2025, Steve Madden filed a lawsuit against Adidas in the U.S. District Court for the Eastern District of New York. And this case centers around two of the Madden's sneakers, especially, really keeping in mind that Steve Madden has different designs, but the specific ones at issue are the Vento and the Janos shoe, which feature two non-parallel, borders or bands. And Adidas is claiming that these designs infringe upon its iconic, as we mentioned, three-stripe trademark. And it argues in this case that consumers might be confused into thinking that the Steve Madden shoes, the two that I just mentioned, are affiliated with or endorsed by Adidas in some way. But Steve Madden is pushing back, and the company is arguing that the use of these banded designs that they're using on their products is common in the fashion industry, and it's widely common, and that Adidas does not have the right to claim exclusive use over all striped products. That's how Steve Madden would sort of frame that argument.
Certainly, and if you look at the screen here, we got the Steve Madden version of the shoe, and there's some similarities, right? You can see the stripes, but notably there's only two of them.
Right.
And whether or not there's an exact match isn't necessarily what you need to establish, right? You need to establish whether or not a consumer is likely to be confused by the mark.
Right.
And here, Steve Madden's, I think they're kind of trying to walk the line a little as close as possible to maybe be evocative of Adidas's brand, but distinct enough that they don't find themselves in legal hot water.
And you mentioned legal hot water with respect to these three stripes. It wouldn't be Adidas's first rodeo with this. So Adidas has found itself in a legal battle over this design many times. In 2024, Adidas actually lost a lawsuit against a French fashion brand by the name of Isabel Marant, and then another brand called Sandro. And these two brands were, having similar arguments that we're seeing from Steve Madden, and the court ended up ruling that the stripes used by the two brands were not sufficient to establish infringement of Adidas's intellectual property rights in the three stripes. And the court also, mentioned this positioning of the brands in the market and sort of what impact these cases have on the market. So it's an interesting development that we're seeing with Steve Madden. It's definitely something that we've seen before with the three stripes in terms of the legal battles that have ensued because of people, challenging that. So it's interesting to see this play out.
Certainly, and I think we should kind of focus in now on what the actual, the catalyst of this current lawsuit, because it's interesting where most of the time trademark infringement suits are, the owner of the mark sues an infringer.
Right.
Where here, Steve Madden they are the plaintiffs, and they're suing for a declaratory judgment, trying to have a court affirmatively state that they are not infringing.
It's interesting.
And they're doing that because they're saying that Adidas has had this history going back, I think, to 2002 of zealously enforcing their trademarks, which, of course, when you have a trademark, you have to enforce it. But you get to situations like this where Steve Madden is saying that Adidas has attempted to monopolize their mark and that they are chasing down, hounding, and engaging in what Steve Madden says is unfair business practices with over-policing.
Yes, Steve Madden is definitely taking an aggressive approach with this case. I think it's interesting to see them take that level of, proactiveness in terms of protecting their products' designs, and that procedural aspect is particularly why I'm interested in following this case, is because of the posture that Steve Madden is taking as plaintiff and the burdens that they will have to meet. It is going to be, like I said, interesting to see how that plays out. We'll see what the court says about this case, but you mentioned before that line between inspiration versus infringement. I think, what does that mean for the fashion and footwear industry, right? When that line is blurred. As brands continue to sort of push their creative boundaries, I think it's important for them to be in contact with their IP team and IP attorneys who can help them sort of navigate the difficult determination of where that line is drawn. And that line can become blurred very easily. We see it time and time again, but when it is with such a big brand like Adidas, the risk is larger. And so it's important for businesses and brands and entrepreneurs to keep that in mind. And I think these legal battles, that we see unfolding are underscoring the importance of understanding what your IP rights are and what you need to do in order to protect them.
Certainly. And I mean, as we tell pretty much all of our clients, no matter how good your case, your arguments are, you don't know the results until the jury makes their decision. So this is a time where possibly Steve Madden was told, or Adidas was told, oh yeah, we can certainly go forward with this, or no, they're certainly infringing. But the only way we get a final answer is here in the courts.
Right. Or negotiating an agreement with another brand, which, that's an option for folks too. But again, all the more reason to keep our eyes peeled to see how this unfolds. So.
Well, this is a very interesting case with two very esteemed brands involved. We'll keep our eye on it and keep you posted.